Major breaking news in the state of New York. The state's so-called red flag laws, or extreme protection temporary restraining orders, have been declared unconstitutional by a judge in Orange County in a particular case called RM versus CM. Stay tuned. We're going to break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay folks, we have some great news out of New York. In a case entitled RM versus CM in Orange County, New York, that's just a little bit north of New York City, a state court judge declared that the state's relatively new red flag law to be unconstitutional. Specifically, Judge Craig Stephen Brown entered an order saying that the state's temporary extreme risk protection laws, for you geeks out there, that's CPLR section 6340 through 6347, is unconstitutional. Now, why did they conclude that? Well, Judge Brown, first of all, cites to the Supreme Court's decision stating that the right to keep and bear arms is a fundamental right that must be provided with the same level of due process and equal protection as any of the other rights, because the Second Amendment rights are no less fundamental than, let's say, Fourth Amendment rights, which is the right to liberty. And thus they must be, I should say, Judge Brown writes, they must be provided the same level of due process and equal protection as liberty. And this is important because when you take away someone's liberty, there's two ways to generally do it. One is to put them in prison. The second way is through involuntary confinement to a mental health institution. Again, prison or involuntary assignment to a mental health facility. Sometimes that's called an involuntary commitment. Now, what Judge Brown says here in this particular case, the way this case arose was in January of this year, according to the allegations in this order, there was a dispute between two neighbors, allegedly, and one of them, specifically the respondent here, who is the person who's fighting the red flag law, allegedly brandished a loaded shotgun, cocked it, and pointed it at his neighbor during a verbal dispute. Again, that's an allegation. We don't know if that's true or not. No way to know. The respondent denied these allegations. Nevertheless, what happened was a petition was then filed in this court arguing that an extreme risk protection order was appropriate, which, of course, under New York law is, quote, a court-issued order of protection prohibiting a person from purchasing, possessing, or attempting to purchase or possess a firearm, rifle, or shotgun. It doesn't say anything about possessing explosives or knives, apparently, or baseball bats and the like, just firearms, rifles, and shotguns. It notes, and then what Judge Brown says, and this is where, in his view, the case goes awry. Judge Brown says that under the red flag law of New York, it allows a petitioner, which means the person who's moving to get a restraining order on someone. It says that the petitioner can be a police officer, a district attorney, somebody like Alvin Bragg, perhaps in Manhattan, a family or household member, a school administrator, or a school administrator's designee, such as a teacher, guidance counselor, or school social worker. Now, here's where it goes off the rails according to Judge Brown. He points out that, quote, while a licensed physician or licensed psychiatrist may, and that's the key word here, may be a petitioner, there is no requirement that such a licensed professional be a petitioner or even be involved in any manner to provide any evaluation or opinion whatsoever as a basis for the issuance of a temporary extreme risk protection order or a final extreme risk protection order. Therein, and this is what Judge Brown says, therein lies one constitutional impediment with New York's red flag law. So the bottom line is, what Judge Brown says is the fact that a licensed psychiatrist, who's a mental health professional, by the way, just as a side note, a psychiatrist is a medical doctor who treats mental illness and can prescribe medicine. That's how I think about it, in contrast to a psychologist, or a social worker who, as a general matter, as far as I'm aware, can treat mental illness, but generally is not allowed to prescribe medications in the same way that a psychiatrist is, because they're not MDs. At least that's my general understanding of the difference between psychiatrists and psychologists and social workers. So again, the point is that the judge says you can take away someone's gun rights, which is a fundamental right on par with the right to liberty. That's what he says, that the Second Amendment and the Fourth Amendment are equally valid, equally fundamental under the Constitution. The Second Amendment, the right to keep and bear arms. The Fourth Amendment, the right to be free from liberty. That's the unreasonable search and seizure and the arrest and things like that. So what Judge Brown says is because there is no requirement that a medical professional such as a doctor or psychiatrist be involved and sign off on the allegation that a particular respondent is a danger to himself or a danger to someone else, that violates the Second Amendment. It violates the Due Process Clause. It violates the New York and the state and the federal Constitution, is essentially what Judge Brown is saying, because he then quotes the New York mental hygiene law, which is like the mental health law, and points out that a person's liberty rights cannot be curtailed unless a physician opines that the person is suffering from a condition likely to result in serious harm. Further, in order to extend any such curtailment of liberty beyond 48 hours, requires a second doctor's opinion that is consistent with the first doctor's opinion. So you see what's happened here? To take away someone's rights under the Fourth Amendment, meaning to take away their liberty by either civil commitment or putting them in prison or whatever it is, you need, under New York law, a doctor to say that you or that person is a danger to themselves or someone else, and you can hold them for 48 hours. At the end of that 48 hours, if you want to continue to hold them beyond that, a second independent professional, doctor or psychiatrist, has to weigh in and offer the same opinion consistent with the first doctor that says that you or the respondent are a danger to yourself or to someone else. So basically, to hold someone for more than 48 hours, you need, under New York law, at least two separate independent doctors or psychiatrists are doctors, by the way, to opine that you're a danger to yourself or someone else. Otherwise, they can't hold you. And because that's a Fourth Amendment implication, what Judge Brown is saying here, and because the Fourth Amendment is on par and equally valid to the Second Amendment, you can't have two doctors needed to take away someone's liberty rights under the Fourth Amendment under New York law, and no doctors necessary to take away somebody's right to keep and bear arms under New York law. That doesn't fly. And that's what Judge Brown said in this very powerful opinion. Short but powerful. Specifically, Judge Brown specifically sums up his opinion this way. He says that the New York red flag law, New York's red flag law does not require even a single medical or mental health expert opinion providing a basis for the order to be issued. New York's red flag law is currently written, lacks sufficient statutory guardrails to protect a citizen's Second Amendment constitutional right to bear arms. Accordingly, the court says, this court joins the Monroe County Supreme Court, which I think we talked about in a prior video several months ago, held the same thing. This court joins the Monroe County Supreme Court in holding that under the relevant part of the New York Procedural Code, in order to pass constitutional muster, the legislature must provide that a citizen be afforded with procedural guarantees such as a physician's determination that a respondent presents a condition likely to result in serious harm before, and this is key, before a petitioner files for a temporary red flag law. This is very important. I want to say this one word. This is very, very important. The judge is holding that the only way the red flag law in New York can be constitutional is if the state provides that before someone can seek a red flag, before someone can seek a temporary restraining order against you that would allow them to take away your Second Amendment rights, before that happens, a physician's, I repeat, a physician's determination, that's a doctor, not some other professional, not a lawyer, not a social worker. It says a physician's determination, which means a medical doctor, including a psychiatrist, who are medical doctors. Psychologists are not medical doctors. A physician's determination that the respondent presents a condition likely to result in serious harm before a petitioner can even file and seek a red flag order. That is very big news. I want to mention there's an analogy here that was not mentioned here. In some states, I'm not a medical malpractice lawyer, although I have a sense of how it works. There are laws in certain states that before a plaintiff can sue a doctor for medical malpractice, which means that the doctor made a mistake, the plaintiff and the plaintiff's lawyer have to get at least one opinion from a licensed doctor, a licensed medical profession, saying that in their professional opinion, the doctor that allegedly committed malpractice did indeed do so. In other words, I'm not a doctor, so I can't just sue someone in New York for medical malpractice. I believe is the case. I think I need to get a doctor to look at the medical records, conclude that medical malpractice occurred, and then only after I got that opinion can I then sue. And I think that basically what Judge Brown is saying here is the same concept, that you can't take away someone's right to keep and bear arms without first and foremost having a doctor, a medical professional, specifically not any medical professional, but a physician, MD, medical doctor, or perhaps a DO, a doctor of osteopathy, sign off and say you're a danger to yourself or to someone else. So to wrap up, big news out of New York today. Let's see how many other courts follow. That's 2 New York State Supreme Court decisions. In New York State, the Supreme Court is the lower court, the trial court, so there could be appeals. But there's 2 decisions in the state of New York saying that their red flag law is unconstitutional. I'll put a link to this one down below. And again, I hope you learned something here today at the 4 Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.